Our first speaker is from the Davis Brown Law Firm. Her name is Allison Wallace. Allison is Special Counsel in Davis Brown's Business Division. She is part of the team that works with the emerging businesses in the Startup Launchpad, where she assists clients in the area of corporate law and software and cyber law. Alice also has significant experience with various business transactions, employment matters, corporate governance, mergers and acquisitions, intellectual property portfolios, and experience in the management of litigation. Allison actually has prior in-house experience as Senior Counsel at GeoLearning Inc. and as General Counsel at Sum Total Systems LLC. With that, I'll turn it over to Allison for the first part of our presentation.
Thanks, Charlie. I hear there's a height differential between Charlie and I, so for those of you that, well, everyone's probably able to see it. Great. Okay, let's dive in here today. Thank you all for coming. My colleague Ware Chen could not be with us today, so you have me for the full first hour. All right, so attorney-client privilege for in-house counsel. A couple of things we'll go over in the first part will be privilege basics, internal investigations, communications with consultants, and then we'll dive into mergers and acquisitions. All right, so looking at the purpose of the attorney-client privilege, we'll go over some privilege basics. We'll talk about privilege in the corporate context, control of the privilege, and scope of the privilege. Just a quick little section on, just the basics of privilege under Iowa law. Ware had pulled out a section out of the Iowa Code. A practicing attorney, this actually applies to several other professions, right? But in their professional capacity, for the necessary and proper to enable the person to discharge the functions of the person's office and to not disclose any confidential information. So really this is a basic concept of privilege I'm sure you're all familiar with. The second piece is that the prohibition does not apply to cases where the person in whose favor the prohibition is made waives the rights. Ergo, you can waive the right to privilege. All right, so what are the benefits and costs of privilege? Well, of course, a few of the benefits are fostering the attorney-client relationships, encouraging client candor, the efficient operation of the legal system, promoting law-abiding behavior, and helping to ensure the constitutional rights. Really at the core of an attorney-client privilege is that we can speak openly and honestly with our clients. And when a client is disclosing facts to us, they're doing a cost-benefit analysis as to what to disclose. So we want to ensure that the communications that they provide to us are protected. Of course, the cost of the privilege is that some may argue it's impeding the search for the truth. Some may hide behind the concept of privilege. Speculative benefits with concrete costs. So again, just a few ways that there are costs associated with the concept of the attorney-client privilege. Privilege in the corporate context. So the privilege is owned by the communicator, the privilege holder, and the decision maker. Well, if you're talking about an individual client, that's the individual, the communicator, the privilege holder, and the decision maker. But in a corporate context, it gets a little more fuzzy. And while there aren't any specific line of cases extending a privilege from the individual to the business entities, we all know that the corporate privilege is assumed. So the control of the privilege. Well, who has the control? The attorney-client privilege belongs to the client, so the corporate client controls its privilege. A few issues that arise because the client, the corporation, has the privilege is the dual representation of a corporation and its executives, in-house counsel communications with employees, always a favorite of mine, parent-subsidiary relationships, and then asserting and who can waive that privilege. So if we talk about some of these issues here, we're going to dive in. We're going to talk about the dual representation of corporation and its executives. So as an overarching theme, maybe avoid at all costs if you can, because you as in-house counsel represent the corporation. But what if you have an executive that comes to you and seeks advice? Well, the executive must show that she approached the counsel for the purpose of seeking legal advice, right? Because if we take a step back and think about what attorney-client privilege is, it's communication with the lawyer for the purpose of seeking legal advice where that communication is meant to be confidential. On the second one, the executive must show that the executive is seeking legal advice in the individual capacity rather than as a representative of the corporation. The executive must show the corporate counsel communicated with the executive as an individual basis, knowing that a potential conflict of interest could result. The communications must be confidential, and the substance of the communications did not concern matters related to the executive's duties within the corporation. So I suppose here, while it's reality that you're going to have as in-house counsel, someone, a director, officer, executive, come to you and want to talk about a legal opinion or a legal matter, you really need to be careful in drawing the line and making sure that, one, you represent the company. You really should avoid representing them individually at all costs. If it's not avoidable, then it should be clearly documented that it's legal representation in individual capacity. The next one is in-house counsel communications with employees. Again, it's important to remind the employees who you represent. This one, when I spent my years in-house, you have relationships with, friendships, peers, non-lawyers in the company, and people want to come talk to you. Oftentimes, you're a bit of a counselor to those other employees in the company. But in terms of legal representation, legal advice, it really is, while not oftentimes the most friendly attitude to take, it really is most important to draw that line in the sand and say, hold up, I represent the company. Let's just be clear on who I'm representing if there is an issue. And then, of course, there's the concept of waiver, which we'll get into here in a minute, but an issue that could arise is if a corporation does waive the privilege, an attorney may be forced to testify against that employee. So I appreciate the uncomfortableness that can cause in an in-house employee setting, but it's reality, and it's one of those just hardline aspects that need to be taken in relationship to your role with the company. Another issue that arises with attorney-client privilege is a parent-subsidiary relationship. So two approaches here, or two different philosophies, is the organizational structure focus. Determine whether a parent its subsidiary may be deemed single or multiple clients. Really is a subsidiary just like the parent, or vice versa, where it really makes sense that it is one client, or on the other hand, are they really two separating entities? And we either need to talk about a joint representation concept, or one needs to seek its own counsel. And the other is just more policy focused, whether a parent and subsidiary would be considered one or multiple clients, and then based on that, how best to effectuate the policy of the attorney-client privilege. I mean, how well can you state and make the argument for attorney-client privilege based on the relationship between the parent and subsidiary? And then the power to assert or waive the attorney-client privilege. So again, when you're dealing with an individual, the individual has that power, but when you're dealing with the body, the entity, the corporation, who as a corporation do you want to grant that power or authority to assert or waive privilege? Is it your directors and officers? Is it counsel? Perhaps a bankruptcy trustee, if that's the situation you're in. I presume no one wants a non-executive employee to be able to waive privilege on behalf of the company. Or what about successors or acquirers? I had a sneak peek at the next presentation, and I know that's going to be covered. So really it is a very good idea in this context to create some sort of policy or credence to live by within the corporation that really documents who has the power and authority to waive or assert a privilege on behalf of the company. So recommendations of going over just a few of those issues we discussed, recommendations based upon those. Avoid the dual representation of both an entity and executives at all costs. Disclose the role of corporate counsel and who counsel is representing by using unambiguous and non-technical language. Maybe in a context of the non-lawyer employees needing your advice. Just make sure it's well documented what your role is in the matter. Be aware of differing approaches to the attorney-client privilege in the parent-subsidiary context, and review company policies for establishing and transferring authority. All right, next up then is the scope of privilege. So applying general privilege considerations to corporate communications with attorneys. The one that Ware pulled up was US v. United Shoe. So the asserted holder of the privilege is a client. The communication was made to a lawyer. The communication was for legal purposes. And the privilege has to be claimed and not waived by the client. So again, just going over a general scope of the privilege. So if we think about the scope of the privilege, then what is the intent of the communication that a lawyer uses, an in-house lawyer then has internally? What's the intent of that communication from the lawyer internally to the corporation? So the focus is on the lawyer. It's the awareness of the multiple roles of an in-house counsel, whether a lawyer is acting as an attorney. The big headline for this part of the presentation is business versus legal. Is the communication from the lawyer for business purposes or legal purposes? And it's very quick to say, it's very quick to understand, except when you're in the middle of those emails that you write as in-house counsel and you suddenly realize, oh, my email has both a business purpose and a legal purpose. So really, for the privilege to apply, the communication must be for legal purposes and for the intent of it remaining confidential. All right. So that really is the scope of the privilege, and the concept about, you know, the legal versus business. You're going to hear me saying that over and over as we get into this. It's, you know, it's an easy concept to hear, except I think in practicality can be very difficult to implement and perhaps to justify if you're ever in a dispute where your documents and your privileged communications are sought to be discoverable. So what about those hybrid communications with both legal and non-legal elements? We'll consider the relationship between the legal and non-legal portions of the communications. Consider the timing. If the reports are drafted quickly and, you know, rapidly so that they can be turned over to counsel, is that maybe for a legal purpose because we're trying to answer a legal question, or is it a report that's being generated in the ordinary course? Maybe it's a quarterly report that you're asking the in-house counsel to opine on. And then at the end of the day, whether the ultimate decision is a legal-based decision or a business decision. If it's a business-based decision, it is almost certain that privilege will not apply. So the scope of a corporate privilege, again, this is step number 2 if we're doing steps in terms of what's the scope of the privilege. And this identifies which employee communication will create that privilege with the attorney. So a couple of areas here. There's one test, which is the control group, which is extending a corporate entity's attorney-client privilege to the corporate employees who are in a position to control or make corporate decisions. The second test is the subject matter test that extends an entity's privilege by the corporate employees to legal counsel where the employees' disclosures were made at the direction of their superiors and the subject matter relates to the performance of their duties with the company. So again, this is where we're talking about a basic community, whether or not privilege applies with employees within an entity. All right, and then Upjohn Co. v. U.S. Happens to be quoted quite often when we're dealing with corporate in-house counsel and the counsel's communications with employees and whether or not they're privileged. So Upjohn, the finding was that the communications, so that privilege does apply between in-house counsel and employees based on a few factors. So number one, the communications were made by corporate employees for the corporation to secure legal advice. Again, this whole business versus legal, here we go again, it has to be legal advice from counsel. The information needed by counsel to formulate the advice was not available from the executives or from management of the company, and the information communicated to counsel was related to the scope of the duties of those employees. And then the communications were ordered to be kept confidential. Oh, and then I missed one there, that the employees that were speaking with the counsel were aware that the communications were for legal purposes and in order for the lawyer to provide legal advice. I feel like I'm beating a drum here with this, but those are the important aspects, really, that the communications with the lawyers have to be for a legal purpose. Here's a case that I believe Ware had pulled from Iowa from 2009, and just another sort of explanation or analysis of this topic, that if an employee of a corporation or entity discusses his or her own actions relating to the potential liability of the corporation, those would be protected by the attorney-client privilege. If, on the other hand, a corporate employee is interviewed as a witness to the actions of others, the communication should not be protected by corporation's attorney-client privilege. Now, on that second part, I'm going to dive in a little bit later on with internal investigations, which does include sort of a witness-type concept where, you know, and with certain recommendations, you may still be able to claim privilege does exist in those witness conversations. And then there's a question here at the end, other means of protecting information from discovery. I apologize, I have no idea what Ware meant by this question. He had no notes related to it, but I'm going to use it as my segue, as the segue into the next presentation, which is, well, let's talk about how you maintain and preserve the privilege in internal investigations. All right, so just a few areas we're going to talk about here. Just the uptick in internal investigations, some recent case law that seems to be indicative on what courts are thinking and how other entities are sort of updating their policies related to internal investigations, and then some other measures to preserve the attorney-client privilege. All right, so a couple of reasons. In the past few years, there's been an increase in internal investigations here in the U.S. For a few reasons. Number one really is the sophistication of companies in their time, resources, dare I say money, into creating their policies, their corporate programs, their compliance programs. I'm sure many in the room or on the phone have either a code of business conduct or an ethics policy in place for your employees with those, you know, anonymous hotlines. And not only is it the implementation of those policies, but also following through when tips are made, when complaints are made related to those policies. So just the sheer fact that companies are now taking the next step and diving in and investigating those complaints. The second reason, and probably the one that the reason that there are more investigations, is a government regulatory requirement. So in the past, I don't know, 8 years or so, you know, we've seen an uptick in requirements from the federal government that if you're a subcontractor of the federal government, there's a self-reporting requirement for fraudulent or illegal activity or other certain types of activity. If you're an entity that handles, you know, credit card information or personal health information, you have certain reporting requirements. So there's several reasons the federal government has sort of push down its self-reporting requirement, which in turn requires a company to dive into its own internal investigation process when a complaint or a tip or an issue has come up within the entity. Again, so the privilege is going to apply if the purpose for that internal investigation is legal and not business. So it's really conducted for the purpose of obtaining legal advice. And if you can make that argument and make sure that that is the mantra that is known to all of those involved in the internal investigation throughout the process, then you have a very good argument for why privilege should apply along the way. However, if the investigation is conducted for business purposes, then you have a slightly more difficult time. Okay, so we have a case that actually started in 2005, but just in 2015, it made its way all the way up to the Supreme Court. We have Barco v. Halliburton and a related case in Ray KBR, Kellogg, Brown and Roots. So in 2005, Barco files a False Claims Act relating to some federal government contractors and what he alleges was fraudulent practices. Throughout the discovery process, Barco learns that KBR had, prior to the Barco case, received a tip along the same lines relating to some illegal activity, and had performed its own internal investigation based on its anonymous tip. Well, Barco learns of this internal investigation, and as you might guess, wants that internal investigation as part of discovery in the Barco case. KBR says no, that was an internal investigation that was for a legal purpose, and of course Barco argued that the investigation was for business purpose. Well, the district court sided with Barco, claiming a extremely complicated and hard to understand but-for test that somehow made its way to the reasoning and analysis that, well, you wouldn't have had this investigation except for the fact that it was government, and for whatever reason the government it was a business relationship with the government, not legal. Ergo, it's a business investigation, not a legal investigation. It took it a couple of steps farther, tried to distinguish itself from the Upjohn case, and said, well, also there were non-attorneys conducting interviews, so that's problematic. And then again, there was no explicit declaration that the investigation was for legal purposes or confidential. Well, KBR says not so fast. We want a circuit court to take a look at this. And the circuit court found the but-for test was a false dichotomy, completely rejecting it, stating that obtaining or providing legal advice must be one of the significant purposes of the communication, that the use of non-lawyers in internal investigations is allowed if counsel oversees the work. And if I can, just step on that, just hold on that for a minute, it's very typical that in an internal investigations there's non-lawyers involved. When I was in-house and we had our compliance program, in fact, if there were two of us that received those tips, I was the only lawyer that received the tip. The head of HR received the other one. So you have a non-lawyer receiving those tips. Well, the circuit court says that's okay as long as the lawyer is overseeing the work. They also dive deeper and say, well, lawyers can't do their job correctly and fully without some help of some non-lawyers. So it makes sense that as long as the lawyer is overseeing the work, as long as the non-attorneys conducting the interviews, doing the research, are directly are responsible to the legal department for purposes of the investigation, and let people that they're working with know that they're part of this legal investigation, that is okay. And then the express notice to interviewees is not required. So the circuit court essentially said there are no magic words. The Upjohn case didn't say that X, Y, and Z had to be said specifically and exactly in order to create and maintain the privilege. So I put final decision, are we there yet? Because then they remanded back to the district court for some other issues. And, working our way along, the case started in 2005. It just ended in 2015 because Barco kept going. He kept fighting the whole way. And the Supreme Court actually denied cert. So I think this is it for now. But as it relates to these 3 points, it's good indication that, if you're working yourself through an investigation, an internal investigation, there are some guidelines and roadmaps, I think, that are very helpful from an in-house perspective. And so because of those, you have measures to preserve your privilege. So it's updating your policies and procedures so that it's explicitly stated in those policies that the investigations are for legal purposes. You have attorney oversight of investigations. They're agents of attorneys, and that the attorneys oversee and review each stage of the investigation. And then you communicate and document the legal purpose repeatedly, often, at each step. Then other measures to preserve this privilege, not from the case law, but just from, very practical items that are used. One is the markings, right? Marking things confidential and privileged. Using the Upjohn warnings in interviews. And as I was sort of reading about this and thinking about this, I had this vision of like Barney Fife delivering these Upjohn warnings, and that doesn't seem appropriate because this process is very intimidating to the witnesses and the employees that are going through this internal investigation. But Upjohn does teach us that there are there are key elements that you at least want to advise people of when you've decided to bring a person into the internal investigation. That the representation from you as in-house counsel is for the company and not for them as an individual. The purpose of the interview is to learn whatever in order to provide legal advice to the company. The conversation is privileged to the company, not to the individual, and the company can elect to waive the privilege. And then the conversation is confidential in order to preserve that company's privilege. So, and you can't, it's important that these items aren't glossed over when you're getting ready to go through an interview, but at the same time to make it, as least intimidating as possible when you're about to jump into an interview when going through an internal investigation. And then the third one, which also seems somewhat obvious until I get to my next piece, which is the limitation of distribution of materials. It's really, who needs to know? I mean, does that party really need to know about the internal investigation? So limit the distribution of materials. All right, so communications with consultants. So again, the basis of the attorney-client privilege, right? So communication with an attorney for the purposes of seeking legal advice that is meant to be confidential. In that context then, what role does that third party play in order for a privilege claim to be made in the event that you find yourself in litigation and suddenly the party on the other side wants the materials, the discussions, the communications, the emails between you and that third party? Most often, it's somehow related to a financial advisor, consultant, but there's actually some very entertaining case law out there about marketing advisors too. Those are just two examples, but I think those are two good ones at least that most companies would be speaking with. And then what is the purpose of the communication? Again, is it business or is it legal? If it's a business communication, it's much more difficult to claim that there's any sort of privilege. And there again, that the privilege may be waived, but depending on what the purpose of that communication is. So United States v. Counsel is a case that we find generally associated with this topic. So a law firm employs an accountant to assist in the law firm client's financial data analysis. Essentially, the lawyer needed assistance in deciphering some financial data from its clients and hired an accountant. While on the stand, the accountant refuses to testify about his communications with that client, asserting attorney-client privilege. And after some back and forth, and the accountant was actually held in contempt, the court finds that the accountant could refuse to testify because the services were considered privileged. And they drew a great analogy in the opinion in this instance, because the attorney needed the accountant to decipher financial data from a client, much like an attorney may need a translator to help translate a client who may speak a foreign language to translate that information from the client. So that was the analogy that the court drew, that the accountant here was assisting the attorney in providing legal advice. The accountant was not providing accounting services, but he was assisting the lawyer in really deciphering some information so that the lawyer could properly provide the legal advice to the client. On the other hand, another example of this framework is where a marketing consultant communications with in-house counsel were not privileged because the communications did not assist counsel in rendering marketing advice. Here we have this case, Church and Dwight v. SPD. Church and Dwight sues SPD. SPD, before the lawsuit, hires a marketing firm to assist in marketing related to an FDA-approved product. And in this lawsuit, Church and Dwight finds out that this third party consulted and provided advice, and they want access to those records. SPD claims, well, no, hang on, those are attorney-client privileged. We hired, our attorneys hired that marketing firm to provide us advice. Well, the court said not so fast. The marketing firm was hired to provide marketing advice, not to assist the lawyer in rendering legal advice to the client. The court also went on to say that, you know, really the marketing firm was nothing more than just a marketing consultant, and that the counsel for SBD could have clearly conveyed and communicated with the marketing firm without having to disclose any sort of privileged information. So just another analysis using that same framework, but you can see the distinction between the two types of third-party consultants and services they're providing. Then we get into another framework, which I thought was also interesting, was called the functional equivalent framework. And here you have a case, it was a copper antitrust litigation. Plaintiff sued a company, Sumitomo, for some global copper price fixing. And Sumitomo, the defendants, hire a third-party consulting marketing firm to really be crisis management. And the opinion reads that, you know, Sumitomo hires them to, one, deal with the complex litigation, and two, to help them deal with Western media, which I kind of got a kick out of, because I can't imagine our media is that hard to deal with, but Western media, that is. But okay, so nonetheless, the court holds that because third-party firm was the functional equivalent of an employee of the company, communications were made for the purpose of rendering legal services. Communications were between in-house counsel and external counsel for the purpose of rendering the legal services. The communications between the third-party firm and the company were protected from disclosure. So really you can see the conclusions are that communications must be made for the purpose of rendering legal advice in order to remain privileged. If the consultant is necessary, ensure the legal need for the assistance is well documented, as well as the legal advice. So if you're going to be using that third-party consultant in a capacity where you need that person to render your legal advice to the company, then ensure that is documented from the get-go. And then just another piece, which is educate internally. Sharing privileged communications with external parties can waive the privilege. And I think this comes into play when you know, the in-house counsel is sending communications back and forth with its executive team, maybe its HR person, maybe its marketing person, and all of a sudden that person then goes ahead and sends it to the third-party consultant thinking, oh, well, we have privilege because my in-house attorney is on the string. So that is not necessarily the case, and so you do want to make sure that really in any of these, whether it's a consultant or just internally, you want to make sure that your peers and the people that you work with around you don't just assume there's privilege because you're involved. Because as we've seen, when it relates to business issues, that is certainly not the case. Okay, so that's what I have. Any questions?
You got some questions.
All right. Okay, so the question is, can you discuss any issues, pitfalls that might arise when outside counsel is also involved with the corporation and its in-house counsel? Well, that's a broad question. I can, and I think really, you know, as in-house counsel, you do want to make sure that these same privilege conversations still apply. And you want to make sure that, so think legal purpose again, right? Just not business purpose. And you also want to make sure that, well, here's an example. I had a CEO once who thought that if he threw me on any email, there would be a privileged conversation, or it would somehow protect him. I had to tell him that not so much after he sent a really inappropriate comment to, a sales rep who he was scolding. So yeah, thanks, but no. So, but there are often times where we have clients as external counsel that think that's the same. And that somehow, because an external counsel is now suddenly on an email, that there's some sort of privilege, there's some sort of right or protection that is automatically maintained, and that's not the case. So you need to treat your external counsel with the same concepts in mind, right? That it's, why are you communicating with them? And let's make sure it's for a legal purpose. So that's what I have for that one. Are there any more?
There isn't any online, but
okay.
I wanted to take some questions for InHouse. Anybody have any questions InHouse?
Well, I'm in annual meeting mode, so hearing none. Well, thank you very much, and please let me know. I think my contact information is on this slide, so if you have any questions, please feel free to reach out. Actually, send them to where? Because that would be really fun for me. All right, thanks, Charlie.
I'm also at the table. What I'm talking, you may want to because that's is it on all the time? Oh, it's on.
I'm going to adjust the camera after you look at that one too.
Our next two speakers are both partners at the law firm of Baker Daniels. Mike Abbott, who's to my right now, I don't think the people online can see, but his practice focuses on corporate and finance law. His clients range from startups to emerging growth companies to Fortune 500 companies, and he's regularly involved in advising companies on strategic transactions, governance matters, including M&A, joint venture, and capital transactions. Presenting with Mike today will be Jesse Linebaugh. Jesse is co-chair of the firm's nationwide securities and financial services litigation practice group. He is an experienced trial lawyer who handles matters throughout the United States. He specializes in financial services litigation, non-compete litigation, and corporate internal investigations. He's a fellow of the Litigation Council of America, has managed litigation involving everything from the manufacturing of glyphosate to, I think that's how you say it, glyphosate, to the cleaning of ethanol plants, and handled court matters in arbitration in more than 25 states. Multiple federal district courts, Iowa Court of Appeals, the Iowa Supreme Court, the 5th and 8th Circuit Courts, and he has also managed regulatory investigations before the SEC, FBI, FDIC, and FINRA. With that said, I will hand it off to Mike and Jesse. Thanks, guys.
Thanks, Charlie, and thanks for the introductions. I like to go before Jesse because then afterwards everybody's, still trying to figure out what all the acronyms are in the last little bit there. So, no, it's our pleasure to present to you all today. We have an interesting topic. At least we think it's really interesting. Especially I do. I do a lot of M&A, and as I was preparing for this, I was reminded that these are the things and the pitfalls that sometimes we find out, and things that we need to be aware of, even in kind of the fast-paced environment that we often operate in when we have clients, and those of you that are in-house, when you have your internal clients that present you with a term sheet and say, we'd like to close in 5 days. How can we do that? And by the way, here's all this information. I'm sure no one here has ever been encountered with that situation before, but no. So this, hopefully we'll have some good practical takeaways for you at the end of the day. And I'm told that we'll do questions at the end, but if you do have anything, raise your hand. We apparently have a live mic that'll be active all the time, so we can just walk out into the audience. So What we're going to do is here's the outline of what we're going to be talking about. At first, I'm going to set the stage and kind of give an overview of the two main points in time where privilege issues arise in M&A transactions, and then we'll go through those in detail. One of those is kind of building off of what the first presentation was about, which is what do you do when you need to disclose information that's privileged information to a third party or to one of your advisors, and is there protection for that, or what are the things you should be considering? The other main topic is who owns the privilege, who owns privileged information at the end of the day in an M&A transaction, and the answer may surprise you, so there's that preview. Then we'll get into just some general other ethical considerations, dealing with conflicts, which Jesse and I, when we were talking and preparing for this, we've all got some real-world examples that we can discuss that I think will be relevant to both in-house counsel and the private practitioners that are listening as well. We'll have some time for questions. And then you may have noticed, if you've looked at the materials that we passed out, we included at the back some sample contract provisions. Those are from the PLC. I don't know if you all are familiar with PLC, and you may have access to them. They're a repository of sample contract information, and they also produce some good guidance. We took that and we can kind of parse that out too, because it does have some helpful information. So talking about, sorry, I skipped ahead too fast there. The two main times where privilege issues arise in the M&A context, it's pre-combination discussions, and those can really take kind of two forms. One is when you're engaging a financial advisor. A lot of times on the sell side, especially, you would engage an investment bank that would be involved, helping you find potential, deciding how the process is that you want to run if you're going to sell a company. For in-house counsel at large companies, if you're going to do a carve-out transaction, sell a subsidiary, sell the whole company, you may have an investment bank and other advisors engaged at the very early term, and you may find yourselves in need of disclosing to them all the dirty laundry associated with the asset that you're looking to sell, so that they can help you decide what the best process is for a sale, if you should be thinking about an auction to maximize price, if there are other considerations that would be more paramount that you'd want to talk about, if how to structure the deal, things like that. So they're probably going to be very involved. The other time where it often comes up is when you need to share information with a counterparty. And you can imagine that comes up at varying times in the deal process. That can happen at the early stages with a simple due diligence request, to post things to a data room or a virtual data room, and we as lawyers need to be cognizant and try to interject and be helpful for what kind of information gets posted in there and how it gets posted, how those answers are given. And then also it comes up in the context of even after you sign a transaction. Certain transactions have periods between signing and closing where conditions need to be met, where regulatory approvals are needed, and during that time there may be issues that need joint assistance and where information needs to be shared. So those, some of the times where information can be shared with a counterparty. What Jesse is going to focus on, and we'll talk more about, is then who owns the privilege, the pre-closing privilege of the target company post-closing. And there are two main types of information that we'll focus on. One of them is what I've called here the ordinary course items, which would be privileged information associated with the business operations of the target. So if you've engaged counsel to assist you with an environmental matter or help you with a potential IP infringement matter, any host of circumstances, that would be what I've called an ordinary course matter. The other one is the communications that are actually related to the transaction themselves. So all the emails, all the communications you've had internally with in-house counsel and externally with your outside counsel, working on deal structure, talking about negotiation of the reps and warranties, why certain things are problematic, you name it, you all know what your emails look like. That privilege is also up for grabs. So one of the things we want to highlight is that it's very important to consider these issues at the appropriate time and at the different stages of a transaction. One thing that I like to keep in mind as I'm looking at this in the context of an overall deal is the the time at which you do this, the different stages, you could have different leverage. If this is at the beginning of a process you think is going to be competitive, you as the seller may have a different ability to withhold disclosure of certain sensitive items, or based on later on if you've gone exclusive with a buyer and they're pressing you for something and you find yourself locked in. And also what we'll see when we talk more about it in the following slides is there's a big difference on the levels of protection that are available at different stages in the process, depending on how common and shared an interest is. And this is more on my topic with Jesse's topic on the ownership of the privilege that doesn't apply as much. One thing that also this seems to impact, at least in my view, this is probably more of an issue for a seller, again, either a corporate seller or individual sellers, than it is for a buyer, just given that the buyer is the one, and we'll get into some examples here to kind of highlight these issues. The buyer is the one that's usually advantaged in the situation because oftentimes, at least in these examples, they were the one that was left with inheriting the privilege, and then in litigation that ensued post-transaction, the buyer was advantaged because they found themselves with the privilege and access to all this information that kind of teed up their case for them. So kind of having set that stage, what we're going to do now is go through a few examples of some seminal cases that are out there across the nation. As you might expect, most of them are from Delaware and New York, since that's where a lot of major deals, the governing law, which a lot of major deals happen, so that's where the cases are. Just to kind of show you where certain pressure points are and how the situation sometimes arises. So the first one is Technoplex. This one arose, it was a post-closing claim based on breaches of representations and warranties from a merger. And what you'll see is all of these cases are based on post-closing litigation, and what we always like to say and note is that post-closing litigation happens, the deal studies would say, about 15 to 20% of the time in litigation. So it's it's a small percentage, but when it happens, it usually is messy and then and results in some big dollars. And also, it tends to happen more in down markets than when times are good, because when times are good, the target company that you bought is making money hand over fist, and you're not, the closing binders with the reps and warranties are sitting up on the shelf. So that's, just one thing to keep in mind through all of this is, we're talking about cases that are probably going to happen 20% of the time on average there. But anyway, so in Technoplex, post-closing litigation, it was an environmental claim, and what ended up happening at the end of the day was the court did a couple things to the dismay of the seller, which ended up being the selling shareholder who was cashed out through the merger, held that privilege for some operational aspects involving the environmental work that was done pre-closing was owned, and the privilege was held by the acquiring company, and that also, and this is something else that we're going to talk about later, the law firm that had represented both the target and the seller was disqualified from representing the seller and on post-closing litigation, and the privilege of all the information for the information was owned by the acquiring company. So as you can imagine, it kind of teed up the litigation for the buyer there. Next one is Great Hill. Great Hill is a case, if you've done any other free reading on the subject, that's getting a lot of press. It's a Delaware case, and it involves the interpretation of a Delaware statute. Jesse's going to get into a lot of detail on that in his presentation. I'm just going to hit the high points, which is the end result of this case, which was, again, post-closing litigation. This one was for fraudulent inducement. And the court, based on interpretation of a Delaware merger statute, again, it was a merger, held that the buyer owned the privilege for not just the operational information that was there, also for all the communications that related to the transaction. That all passed to the buyer. So the seller was left without any privilege protection. One other case to distinguish, and I think it's an important one, is the Sovereign Software case, because this one is different than the first two in that the first two were mergers. This one was a limited asset transaction and involved a purchase through bankruptcy. So there were several layers here, but even at the end of the day on that one, the court ruled that the privilege related to certain patents, so all the privileged information that related to the assets that went along with the business of those that was conducted with those assets, passed to the acquiring company. And on that, here the distinguishing factor again is that the seller in that case made the argument that tried to distinguish that case from the other ones that were out there by saying this wasn't a merger, this was a limited sale of certain assets. How could privilege pass? We were merely selling tangible property, and in this case intangible property. And the court said no. If you look at the facts and circumstances, yes, while you were selling assets, you weren't passing along, and there was no assumption of liabilities. In fact, it constituted a business, and because of that, the privilege passed too. And before we drill down into more nuances, I thought we'd take a brief second just to kind of run through some terminology and some structure items, because we're going to be talking a lot about kind of the impacts of different structures, and I thought just to kind of help just for those of you that don't live in the M&A world day to day. Here's some terminology that I'm using, and then I have charts on the next slide that we'll run through that I think will be helpful. So when I say asset sale, what that means is a selling entity or individual, usually entity, corporation, sells certain assets, transfers certain liabilities to a buyer. Stock sale would be the sale of the equity ownership of a company by its equity owners to another company. Merger would be a combination of a company into another one. I'm going kind of faster because we're going to cover these in more detail on the next slide. The target, that would be the asset that is being sold, usually the company. So if it's an equity sale or a merger, that would be the company itself. If it's an asset sale, the target would be the company, the seller's assets and liabilities. When we get into the potential protections for pre-closing communication, we'll talk about a timeline, and in that timeline, we'll distinguish between pre-closing and post-closing. Closing just being the time upon which you actually affect the transaction. So when you've closed, when the buyer has wired the money to the seller, that's the closing. Pre-closing is just that period before, and that would include both pre-signing and post-signing. I kind of hit on that a little bit ago. Pre-signing meaning before you sign a purchase agreement, post-signing meaning after you sign a purchase agreement but before you've closed, and that's the last definition there. So here's some diagrams that I think may be useful, and I kind of want to emphasize this because as I was first becoming aware of these issues, my first inclination was this is really only an issue if we're talking about a stock deal or a merger. I mean, an asset deal has to be viewed differently by the courts in terms of, especially on the ownership issue, because that's just a different creature. The company, the seller is staying there, the legal privilege should remain, and as we'll get into later in more detail, that's really not the case, so I wanted to kind of highlight that. But here's the differences in how they look. So in a stock purchase, again, you have B being buyer, S being seller, and then S being the target, and then S shareholders being the sellers there. And then in a carve-out transaction or a sale of a subsidiary, there could be the seller there could be the shareholder there could be another entity. Asset purchase, you'll see that the entities remain the same. It's just a transfer of assets, maybe liabilities, and then consideration. And then in a merger, you'll see that at the end of the day, you end up with one entity. So there's the entity, in my example, it's just a straight merger where the target goes into the acquirer. So now kind of our first main topic, which is what, if any, protections are available for pre-consummation discussions, and giving it away, the protection that may be available is something under the common interest doctrine. And we've kind of touched on this before, but this is more or less setting the stage. So we've already briefly mentioned, or I've already briefly mentioned that disclosure of sensitive information, oftentimes including attorney-client privilege communication, is required in an M&A transaction. I'm not sure I can think of one deal that I've worked on that hasn't involved some sort of disclosure at some point. Usually it's something that's as as a part of a virtual data room, or just on the sell side, you just have to put information up there for the buyer to do its diligence. But this includes disclosures to advisors and also to counterparties. And those of you that have been through this process know that a buyer is commonly going to request things as part of due diligence. Oftentimes then there may be shared interests in regulatory issues. There may be shared interests in defending joint litigation that we think is likely. That's oftentimes that comes up in regulated industries or in industries where there's been a lot of issues, a lot of financial services litigation, and deals are what's referenced and what we found that exist. And that sellers need to oblige here, or they risk negatively impacting the deal. And this is where I want to point out, kind of my take on this is that the privilege issues is just one issue of many that we all have to think about in the deal context. And it may or may not be material in the transaction. If you're working with a company that is very clean, has had very little litigation, there's very little risk, you may not have as much sensitivity about trying to cordon off potential pre-closing disclosure, waiving privilege on items, versus if you're in you work for a company or you're representing a company that's in a heavily regulated industry that's under a lot of scrutiny, that has multiple subsidiary, a lot of commingling of communications because you have a vast network, you're at a large company, then we oftentimes see that that's taken very seriously, even on deals that would be under a reporting threshold for a public company. They're paying attention to this just because they want to very much make sure that they're protecting their privilege for, that being the leak that breaks the dam and causes some catastrophic risk. So what we're talking about here in the first presentation, we set forth the general rule that the attorney-client privilege generally shields communication between an attorney and a client, and the general rule is also that protection is usually destroyed once that communication is shared with a third party. And there are exceptions that exist for that, and some of them were touched on in the first presentation. We're going to drill down on one of them here, which is something called the common interest doctrine. And what that is, it's an exception to the general rule that privilege is destroyed when a third party is present during communications between a lawyer and their client. The distinction here, this is not joint representation. So that's the exception where one lawyer is representing two clients, but it's one lawyer. This is where there's a disclosure, and there is the attorney-client relationship is between one lawyer, one client, and then there is a third party in the room. That third party, as we've said, could be a financial advisor, it could be the counterparty, it could be the counterparty's advisor. So, that's what we're talking about here in terms of what the common interest doctrine protects. And generally, for this exception to apply, the communication at issue first must otherwise be privileged. So all the things that the first presentation hit on about what it takes to have a communication that is privileged, for the exception to apply, first that has to be true. And then the next part is that the communication has to be made for the purpose of furthering a common interest. And in the next bits of the presentation, we'll get into further what that means as to what a common interest is. So in the M&A context, this is meant to give you some comfort when you're in the process that you can facilitate legal advice through the assistance of your financial advisors and bankers, and then also how you can share information with counterparties. So for the exception to apply and for the what type of communication must exist and the relationship, the shared interest has to be legal and not commercial. My first thought on that, well, what's the distinction? There is very strong case law that says that an interest in consummating a transaction is not legal, it's commercial. So the joint goal of getting the deal done is not a legal interest, it's a commercial interest. What there has to be is something more. And there are a few schools of thought and approaches to what it takes to be a shared legal interest. There's what I've called the New York approach, which is the strict approach, and that means in order for the common interest exception to apply, litigation against the parties has to either be pending or reasonably anticipated. The main case on this is called AMBAC, and there the court upheld common interest between two parties in a merger, a potential merger, because for certain communications they were having about litigation that was pending against both the parties, that was brought by basically their customers. It was, I think, credit card, kind of financial services regulatory violations is what was happening. I'm looking to Jesse because if you remember from his bio, he does a ton of that. But that was pending, and then the two camps had met prior to post-signing, but prior to closing, to decide how they were going to deal with it post-closing. And the court said, yep, that's enough for a common interest under New York law, but less than that would not be. The Delaware approach, which is a very broad approach, there it says that the parties must share a legal interest, but litigation does not have to be pending or reasonably anticipated. An example there would be for the parties to get together to talk about how to jointly obtain regulatory approvals. There again, the cases point usually to deals that are done in regulated industries. So if you need to go get state insurance department approvals because you have two insurance companies that are looking to combine, federal antitrust approval, things like that, that's enough in Delaware. If you are further enough down the line, you can those communications are protected. And then kind of generally around the country, most courts, federal and state, they follow the somewhat closer to the Delaware broader approach. I will note, though, that we are in a state that does not seem to have officially adopted the common interest doctrine. As I've asked around to some of our colleagues, I think the consensus was that litigators in the Iowa bar believe that something likely exists, but no court has ever really come out and said anything on it. So I took note of that, and that also the 8th Circuit hasn't officially adopted it either. So my takeaway from that is that choice of law in your deals could be extremely important. A lot of deals we see, are Delaware and New York law, and oftentimes, you hear when we're down to that part of the negotiations and we're trying to weigh the pros and cons of choice of law, this should be one of the things you consider. If privilege is important to you, if ownership of privilege is important to you, maybe add that in terms of when you're considering choice of law to your issues list. So talking more about the discussions with counterparties, it's a very fact-specific test. Assuming that there is a common interest doctrine in your jurisdiction, the application of it is very, very fact-specific and deals with a few things, one of which is the timing of the disclosure. Again, to decide whether or not the parties have a shared interest, you can imagine that courts are looking at things like, was the disclosure of the privileged information, did it take place very early on in the process? How many potential buyers were there? Was it likely that this was actually a shared interest because there was going to be a closing, at which point the buyer was going to own the seller, or was just something that was done for a commercial purpose of trying to get a deal done? Also kind of building from that, certainty of the transaction, same thing, is it pre-signing? When is the disclosure happening as a discussion? Is it happening prior to the signing of a definitive agreement, after the signing? Even if it happens after the signing, is there still a stalking horse out there? I mean, these are all things that have been analyzed by a court to see whether or not the parties actually, in fact, had a shared interest. And then also, again, the purpose of the disclosure, was it just to further get the deal down the road, get it to closing, or was it actually to address something of a shared legal interest? And then the other factors that courts look at, one of them is whether the parties are adverse at the time the disclosure is made. So courts have made distinctions about, even at a certain time in a transaction, if the parties are negotiating the terms of the deal and then in the same discussion move to an issue of shared interest, of legal interest, courts have been asked to kind of split the applicability of the common interest doctrine, and they'll say it does not apply to the negotiations, but it does apply to the disclosures pertaining to the shared interest. And one thing that I'd advise is that if you carefully plan those discussions and you have them take place separate calls. So if you have a team calling in to negotiate a purchase agreement, you do that. You have that meeting, you conclude it, and then everybody calls back in and then talks about the shared interest. I think that's, as we get into the kind of the takeaways and we talk about kind of building the appropriate record, that's one of the things that I'd highlight there. Another thing that a lot of courts have looked at in deciding, again, whether or not the interest was shared is whether or not the disclosure took place prior to the time that the parties had entered into a transaction agreement. So even they haven't closed yet, but have they entered into an agreement? Seems to be a very big milestone for when you can take more comfort in the fact that you may have a common interest exception available. The open questions then on discussions with counterparties are, what stage of negotiation is required? There's really no bright line test. This is all facts and circumstances, and it all builds upon itself. Again, pre-signing, so if you're going to disclose these things and you want to rely on the exception, pre-signing remains very risky. If you can show that, after you've been married and that, you're contractually bound with each other post-signing, that's a much safer time to do it. And then also something that's a bit of an open question is whether the exception extends to the advisors of counterparties. Courts have looked at if a disclosure is being made between two in-house legal teams or two in-house legal and business teams, but if you get a situation where you have the advisor, non-legal advisor for a counterparty being fed the information directly or being involved in the information receipt, that may also jeopardize the privilege. So takeaway there is if you have some very sensitive information, something you're trying to protect in the utmost, control who is on the receiving end of that. Moving on then to the protections when you have your own financial advisor involved. And the first presentation touched on some of this with consultants and employees, and I took some comfort in seeing that it's a very similar analysis, almost the same. So that's good that there's some commonality here. And what we're looking at here is to determine whether or not the disclosure to a financial advisor or investment banker waives the privilege. And courts that have looked at this, they look at a few things. One of them is whether or not the financial advisor is a functional equivalent of an employee of the client. Here, courts that rely on this have a varied scope. They look at how many clients does the advisor have? Are they really, do they have one, are they an independent contractor? They're called an advisor, but they really have one client, which is the company. They work in that client's office. They have done that for a long period of time, but just out of convenience, they're not designated as an actual employee. Some courts have required that level. Others have been much more accommodating and said, look, it's any investment bank, basically. Like, any advisor that's there is okay. So there is a scope there to be considered. Other bright line tests are, why is the financial advisor involved in these discussions? And so a few things, some courts say the common interest doctrine only applies when a financial advisor, banker, is necessary to translate and help the client understand and evaluate the legal advice that their in-house and external lawyers are giving them. So in the context of the transaction, the financial advisor translates what we lawyers are telling the client and helps them understand the situation. That's an extreme example of what's required. Again, there's varied scope. Some courts have said that's required. Others have said it's not that extent. We do require that the advisor be there for some reason. You can't just have them in your meeting and that's okay. But if they're there for the purpose of the client obtaining advice, maybe they just kind of help get the meeting together. That's kind of one end. That's a very broad approach. Others are if their presence is necessary for an effective consultation. So something less than translating, where we're speaking Greek and they're translating it to English, something more in the middle of the road, maybe helping understanding nuances and context and more kind of commercial advice. Some courts have said that's okay. And again, so the broadest protection, which is one I just highlighted, perhaps not surprisingly, that's Delaware's approach. Delaware actually has some good statutes on this that provide pretty strong protection to upholding privilege. So some takeaways on this are, if disclosure prior to a transaction of privileged information is something that you identify in your transaction process, it's important to you, it's critical because you have sensitive information, or otherwise it would disadvantage you if the deal didn't happen, or thinking about post-closing ramifications, because you've lost a privilege. These are the things that you can do to help bolster it. One is build a record for your financial advisors. Build a record, board minutes supporting the need for the financial advisor to be there, for why they're at the meeting, how they helped, what participation, what value they added. Another one is, if you're going to have a highly sensitive discussion about something that's purely legal in nature that you want to make sure is privileged, exclude them from the conversation. Just have them step out of the room so that you don't even have to worry about their presence. And so the protective measures, again, the extent of the protection varies by jurisdiction. In particular, think about what we told you about Iowa and the 8th Circuit. Choice of law is going to become very important. Another thing is, recognizing that you have a choice of law in your transaction documents that govern your deal, you may have a different law apply for your internal affairs when you're having conversations with your advisors. It's not necessarily going to be the same law, so you could have multiple jurisdictions. So that's something to analyze for your specific purpose and what you've got going on, and being mindful that you may have multiple jurisdictions in play. M&A lawyers consult with litigation colleagues. For those of you that are like me that live in a transaction world, this is not my day-to-day. I go to people like Jesse and others, and whenever something like this comes up, and kind of have them help, walk me through privilege issues, confidentiality issues, all those things. That's one other takeaway that I would highly recommend. One thing, too, that you can consider, and the rest of these bullets are all about establishing a record that shows how serious the efforts were to protect the information and their disclosure and their privileged and confidential nature. Courts, when they look at this, oftentimes will remark, sometimes just indicative, but they'll oftentimes remark whether or not the party that's now asserting that privilege is available, whether or not they took steps proactively at a certain point in the process to protect it and to clarify and to document that this information was important, and that they had a plan in place, that they were limiting the individuals to whom the disclosure was made. If it was highly sensitive, did they wait until that there was definitely a shared interest, and did they take substantial efforts to limit and maintain confidentiality? One last point that has occurred to me that I'll bring up, it's kind of beyond the scope of this presentation, but for those of us that do a lot of deals, one thing that you may be encountering now is the onslaught of rep and warranty insurance. And there is also now, we're starting to see cases about depending on if it's a seller policy or a buyer policy, but the ability to maintain privilege when a seller is disclosing information to its rep and warranty insurer, because the rep and warranty insurer is going to then insure the deal, whether or not that can result in waiving a privilege. So one thing also now to think about is, if you've got that added extra layer of complexity on your transaction, you also need to be thinking about privilege issues with that as well. All right, so I am now going to turn it over to Jesse to talk about ownership.
Well, thank you very much, Mike, and good afternoon, everyone. It's a pleasure to be here. A couple just initial thoughts, three actually, before we get started into the substance. The first is I want to send my thanks and apologies for our Terry Combs. She's our senior partner in our Des Moines office. She was originally to be given this topic today. She approached me because she had a conflict, and so she explained to me what we're doing, and I'm thinking to myself, all right, Thursday afternoon on the beginning of spring, nice day, talking about ethics. Thanks, Terry. It's a little bit of tough sledding here, but hope everybody is getting into the presentation. The second comment I'll make is it's a little difficult for me talking at length about the origination of M&A deals. I don't do that. I'm a litigator by nature. I work a lot with Mike, but I only work on things once it gets ugly. To be frankly sharing a room with people like Tom Slaughter, my former colleague at Faegre, that are true experts in this area. And Mike Abbott, he's much too modest, but I mean, we are a big firm with offices nationwide, and I tell you, literally, people call him from other offices. He leads deals nationwide for Target, Polaris, Cargill, Hormel. He knows this stuff and knows it very well. So to be sharing a stage with regard to the formation piece certainly is not my strength. That's not what I do. I deal with the ends of these issues. The third comment I'll make is when I was approached to help with this, whether that was last week or 2 hours ago or whenever Terry told me, I was trying to summarize what we're talking about here, and I think as litigators, we constantly are thinking about privilege. It matters to our cases, it matters to our clients. We win and lose on that issue a lot. I think on the deal formation side, it's a little bit different sometimes. I think people are happy, you're trying to get a deal together, you're trying to make money, both parties are happy. But our point here and the takeaway is it matters at that stage too. It matters very much, in fact. And the consequences can be real. The consequences can be real both for the buyer and the seller, and frankly can be real, as we'll talk about as we give some examples on conflicts. I think it can be real for some of the players involved as well. You could perhaps lose your job. You could perhaps no longer have a client if you're an outside lawyer. These are things to think about. We've given a lot of examples already. When you dive into this case law, it's not like it's very black and white, 2 + 2 = 4. Almost all the cases are fact specific, and we've got into a few of those facts, and we'll talk some more on that. The takeaway is simply make sure you're thinking about these issues at the time the deal is formulated, and work to document those deals, work with lawyers like Tom and Mike who can do that. And additionally, if you think there's conflicts, as we'll talk about at the end, disclose, disclose, disclose. I mean, you want to make sure that you are not going to conflict yourself out of something, whether you're the outside lawyer or the in-house lawyer. So I think that's the general takeaway. We'll jump into a couple of these topics. What I'm talking about is ownership of pre-closing privileged communications. So we're going to talk generally, what is the general rule? I mean, what happens with the acquired company's privileged information, and how is that treated post-closing? And the general rule is when control of a corporation passes to new management, the authority to assert and waive the corporation's attorney-client privilege passes as well. So that's the general rule. It's very important to keep that in mind on any transaction you're doing. And I have this next bullet that says courts have taken varying approaches to this rule. That's what I was mentioning before. I mean, we could be here and write a long essay on how courts look at it because the facts of each case are a little bit different. But you need to keep that general rule in mind. And the other general rule to keep in mind, and perhaps most importantly, is it's based on the passage of control. So the form of the transaction is not as important. It's who's controlling the corporation at the end. And there's just practical, it's called the practical consequences approach. We'll talk about that as we move forward here with, who is actually controlling that company. And the last bullet point's not surprising. I mean, as Mike talked about, we do live in a state that doesn't have the breadth and depth of case law as some other jurisdictions. So not only are we in a situation where the facts of case law are different everywhere, but we're in a jurisdiction that doesn't have a lot of cases defining it specifically. So if you get into a fight and we're in our jurisdiction, we're going to have to make arguments based on what other courts have decided and done. So that's important to know, and it's important to go back to what Mike suggested, which is make sure you select your forum selection clauses in those documents wisely. The Great Hill approach, or the Great Hill case, is one of the examples. That's called the Delaware approach. It's really the bright line rule. It states that all attorney-client privileged communication, whether related to business operations or negotiation of merger, pass to the acquirer unless the parties agree otherwise. So that's the bright line rule. What's a little unique about that is that case is cited a lot in secondary resources, but if you read the case, it's actually based on a statutory interpretation of a Delaware statute. So again, it's unclear. Going back to the, there's a lot of murky water here. It's unclear if the same result would occur on account of an asset sale or a stock sale, because at that point the statute wouldn't be involved. Another case we've talked about a lot, and again is cited in all the secondary resources, if somebody comes in your office with this issue and you start doing a little research, this is one of the cases that come up all the time. It's the Techniplex case. And a mere transfer of assets with no attempt to continue the pre-existing operation generally does not transfer the attorney-client relationship. The structure is not the factor. The test is whether the buyer is continuing the business operations. So again, think about it from products, clients, suppliers, non-managerial personnel. Are you continuing the business operations of the seller? That's the takeaway from Techniplex. It's generally considered the New York approach, and the privilege for business operation transfers to the buyer, but privilege related to the transaction remains with the seller. And another issue with regard to commodity futures trading, that privilege passed to the bankruptcy trustee who assumed managerial responsibility. So yet again, another nuance depending on who's involved and what's involved. Another example of a case that's out there is the Posta Revo matter, and that's an asset sale where certain assets and liabilities were excluded from the transfer by the express terms of the asset purchase agreement. The Delaware court, applying New York law, The seller retained control of privilege related to the pre-sale communications about the excluded assets and liabilities. And the asset purchase agreement specifically addressed that seller retained privilege related to the transaction.
Hey, Jesse, can I?
Please.
So one distinction in that one, sorry if you guys can hear me, what I look at with Post Aribo versus Great Hill, and Jesse made the great distinction, which is Great Hill was a merger applying Delaware law, and there was a Delaware statute. What Post Aribo is a Delaware court in an asset transaction applying New York law, and the distinction there is that under New York law, it's the privilege of the business operations, so that distinction we made early on, it will pass to the buyer, but the seller retains the privilege for all the transaction discussions. Under Great Hill, which again was Delaware merger statute, that's where the whole kit and caboodle transferred, which was business operations, and all the communications were in the transaction. So this, as Jesse and I were preparing for this, and I was trying in my own mind to make a distinction by how you can have the Delaware court basically saying two different things. To me, I hope, candidly, although it's Mike Abbott's opinion, that Great Hill is limited to its facts, and that Post Aribo is the broader law. But that's to be seen. But anyway, sorry I interrupted you guys.
No, and I appreciate that. And if you guys have any questions as well, obviously jump in. This next slide shows the statutory comparison in Iowa and Delaware. I think it's worth noting here that there is a difference. The Iowa statute says that the effective merger or share exchange provides that when a merger becomes effective, all property owned by and every contract right possessed by each corporation or other entity that merges into the survivor is vested in the survivor without reversion or impairment. It's worth noting on the Delaware statute that all property rights and privileges, powers and franchises, and every other interest shall be thereafter as effectually the property of the surviving or resulting corporation. So obviously under Delaware law, all truly means all. It's important to note again on your form selection. And the privileges includes legal privileges, not just privileges related to assets. And these are differences that do matter in the scheme of things. Your takeaways, and I think Mike's going to jump in here with some more practical experience on how this works in the formation stage. But it's similar to the common interest doctrine that we talked about. And as I said before, it does matter. Choose your law wisely. Think about these things at the beginning, because there's a lot of things you can do. We've listed some up there, whether that's address your post-closing ownership, control and transaction, and there's some things you can do with physical files and segregation. But Mike, why don't you jump in here and give them some thoughts?
Yeah, sorry, this is I know a little clunky, but a couple things that as Jesse and I were kind of talking about this, and as litigators and transactional attorneys sometimes do, when we're just trying to test each other's thinking on how things will work, and if things go unfortunately, in my view, what we can do best to best position litigators like Jesse, to defend our client and make sure that they have, we haven't given away the kitchen sink, and they've got, don't have, they're kind of working to crawl back. But a couple things that I've seen that I'd point out is, especially in the context of a carve-out transaction. So at a big company, a lot of times, there is a centralized IT department and that controls for system-wide, and there is information housed on servers, sometimes at the sites that you're selling, sometimes at the sites you're not selling. And one of the things that we try to do is to make sure that on our deal teams, where they include large in-house personnel, is that you have representation from each functional area, including IT, to really understand, okay, when our purchase agreement, let's say it's an asset, a carve-out deal where you're just selling, you're structuring it as an asset transaction, and we're selling assets, we're transferring certain liabilities. What's on those computers? Tell me what's at the site. What's at these 19 locations? Do you have emails to your outside counsel on there? Are my emails on there? I'm sending you about, oh geez, what this rep says and things like that. Or, and how are we going to wipe those? How do we make sure that what we get, that's when you're on the sell side. And when you're on the buy side, of course, you're thinking about the exact opposite. Like, are they going to wipe the systems? And that's just kind of a practical commercial issue. What am I buying? A lot of times we'll consider that and try to contract. We'll put covenants in our agreements that say the condition of how we're going to actually receive things when we're buying subsidiaries from a company that we don't have a history with, and we don't know what kind of how they're going to leave it. But just in terms of, if you want to make sure, if you're on the selling side and you want to make sure that you're taking steps to protect the documents, and all the privileged communications. A couple things. One is we can talk about later the way to document it, which is in your purchase agreement, and the stuff at the back of our presentation gives a good example of kind of hitting all the three areas in one fell swoop. It addresses a conflict issue that Jesse's going to talk about next. So how you can ensure that if you're on the sell side that the buyer will not assert a conflict of interest with your seller's counsel, because that seller's counsel is represented selling shareholders and also the target company that is now a subsidiary of the buyer. There's ways that you can try to contract around that, or get something at that stage in the deal where the buyer agrees that your counsel can continue to represent them. Also, you can contract in, because most of these courts have, in their decisions, the first thing they do is they say, we will uphold the benefit of the bargain that the parties strike. So if the contract talks about transfer of privilege as part of the assets or part of the things that are retained, even in an equity deal or a merger, courts have, I've not found one instance where a court said, no, we're not going to agree to that. So courts will honor the bargain. So if you put it in an agreement, that should be the lay of the land, which, again, Mike Abbott talking, I think that's much more important on the sell side than when you're on the buy side, because it's usually there where you have the greatest risk, as we pointed out, that privileged information is going to become the property of the buyer if you're silent on it. The other thing is in an asset deal, we've all seen the standard form asset purchase agreement that has, usually towards the front, a definition of the business, and then it says, sometimes there's a catch-all in terms of the assets that are being sold, which says, we're buying this laundry list of items, but also, by the way, we're buying all assets associated with the business. So that catch-all there may be enough to say, I'm also, as a buyer, buying all the privilege. As Jesse noted, the courts look at it's a facts and circumstances test about whether or not the business transferred, and the business can just be, as we've heard in post-Aribo, 2 patents. So that's enough. That gives me pause. And I know then what we are seeing more often in asset deals even is, which I, a few years ago thought was overkill, in the excluded asset section then of the deal, where sellers are taking steps to clarify that privilege isn't transferring on any, whether or not the privilege is transferring or whether or not certain privilege for certain things are transferring. A deal we were involved with last year at some point, it was one of those all assets of the business. It was somebody, a company cashing out, we were being absorbed, so it wasn't like anything was being left behind. But one thing that was being left behind was some litigation. And they took steps to make sure that the privilege associated with that litigation also stayed back, because there is also case law that says that when even if you exclude the asset of litigation, you don't necessarily automatically get the privilege with that as well. You may, but you don't automatically get the privilege too, so you may have to be going to your buyer to get that information, at which point then you may have destroyed the privilege for all the reasons we talked about, and then your counterparty's got access to it. So that's kind of the takeaways that I had from that, that we kind of wanted to touch on. If you look at the practical law document, the language, it does a good job of, one, identifying and dealing with the conflict issue, and then also dealing with the ownership issue. And then there's a few notes in there that practical law puts in where if you're a seller, you may want to consider this. If you're a buyer, you may want to consider some other things. Of course, we have our own kind of documents, but I felt like this was a good way to share it and just kind of show some general language. But anyway, that's just kind of we wanted to touch on in more detail. So I'll turn it back over to you.
Well, we figured we would end the presentation today by, we've talked obviously about at the merger and acquisition stage, at the formation of the deal, considering attorney-client relationship. One thing we figured to complete our hour is we would talk about some of the conflict issues that arise at the merger and acquisition stage as well. Obviously, to have an attorney-client relationship, you got to be somebody's attorney, and the rules are very clear that if you're somebody's attorney and giving advice, you cannot give somebody else conflicting advice. That does arise occasionally in the merger and acquisition area, and I figured we would go through some of those. There are certain transactions. There's obviously a potential for post-closing disputes regarding conflicts and potential disqualification of a seller's counsel. The issues arise in stock sales and mergers. We're going to give a few examples. When seller's counsel represents both the selling shareholders and the company. Post-closing, the company is a subsidiary of the buyer or merged with the buyer. And situation can arise when interest of the firm's current client, the seller, can be adverse to the interest of the buyer, and unless steps are taken, the buyer can move to disqualify our seller's counsel on the grounds that the buyer holds the privilege for the target post-closing. So these are some of the issues that may arise, and you know, again, they can be addressed in the definitive transaction documents. That's key. That's what Mike does. That's what all the great the lawyers who are putting together the deals are going to be working on. Why is this important? Is what I talked about before. Iowa rule requires that you have independence of professional judgment. No reason to read that statute. Everybody knows every state has one similar, and the model rules of professional conduct probably keep it most simple, which is a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. So I think maybe the easiest thing to do is go through a couple examples. And if you have any questions on these, you know, Mike can take the microphone and be like Phil Donahue and bring you the microphone, and we can try to answer. But what about this attorney-client privilege conflict rule in situations where the buyer's law firm used to represent the seller? Let's give a hypothetical. The buyer's law firm had previously done about $2 million in work for the seller's law firm, but the relationship had ended about 4 months prior to the attempted purchase. Can the seller get the buyer's law firm disqualified and or file suit against them? Well, this is one that there is actually a specific answer. There's been a case very similar. Of course, they can fight to do that. It's probably not likely to occur in a traditional merger and acquisition setting, but certainly in a hostile takeover, you'd want to be very cautious about that. And we bring this up because in 2010, Cravath was serving as a legal advisor to Air Products on its hostile bid attempt of Airgas under the exact same scenario. It had done a lot of work for Airgas and had millions of dollars in work. The Delaware courts did not disqualify Cravath under these because the standard at that time was the representation had to materially advance Air Products in its bid, and the court determined it hadn't. But the parties did reach a breach of fiduciary duty settlement out of court. So this is just an example of something, again, to be cautious of. The conflicts very well could arise and can occur, particularly when you're an outside counsel and you have many clients. So when you're approached by this, and when you're in-house counsel choosing clients or choosing your outside lawyers, you want to be cautious of these issues as well, because clearly there are ramifications that could result in a monetary settlement. Another issue that may come up, what about the attorney-client privilege conflict rules in situations where an in-house lawyer decides to take new employment at the seller? Hypothetical. The outside lawyer for a seller in a stock sale is offered a job with the buyer after the close of the transaction. She accepts the job. Months later, a problem arises and she is asked to lead the indemnity claim against the seller. Can she do it? How should she handle it? Well, the answer is, of course not. That's a direct conflict. That's a perfect example of a direct conflict. Attorney should recuse herself and wall herself off from the dispute. Unfortunately, there are situations out there and some case law and examples where situations like this have occurred. As I'll talk about in the end slide, and I talked about at the beginning, anytime there's a potential conflict, you must disclose as a lawyer. Whether you're in-house, whether you're outside, you must think about these issues, because when deals happen, often the buyer and seller get close, they start to know where talent is, and personnel does change back and forth, and sometimes those are lawyers, so you want to be very cautious of what you're dealing with. Another hypothetical, the buyer's outside law firm has been hired to effectuate a merger with a seller. Buyer's outside law firm runs conflict, and there is no conflicts with the seller. But during the course of the due diligence, we find out that the seller has, an issue with company A, and there's a lot of privileged information about that lawsuit. And as part of the outside lawyer's duties to the buyer, they have to do due diligence on that. What's the risk in that lawsuit? What's the exposure? What's the settlement negotiations looking like? And as part of the due diligence, you got to roll up your sleeve as counsel for the buyer and look into that. What happens when you find out that company A is who the seller has a conflict with, and company A is one of your clients? This happens quite a bit on bigger firms, quite honestly, and it's one thing you want to be very cautious of. The answer's, as what we've been talking about before, the answer is you definitely got an issue. What your issue is you need to obviously get your conflicts counsel, your general counsel looped in on this. You need to disclose to both parties, and more than likely, disclosures will take care of it. But it's not something you want to bury your head in the sand in. And just because you're trying to do the best job you can as buyer's counsel doesn't mean that you dig in and start researching that, because you have an obligation. If you find out information from the seller that could help your other client, company A, you have an obligation to turn that over as well. These are real issues. You'll have to wall yourself off. and I think unfortunately they happen a little bit too often. Another hypothetical, law firm represents Company A. Company A merges into Company B. Law firm tries to sue Company B later in an unrelated matter. Unfortunately, a few of these are out there as well. Company B moves to disqualify the law firm. Will it succeed? The answer on this one's yes. And this one seems more, obviously all of these are fact specific, but on this situation, by virtue of the merger, the law firm now represents Company B. So that's something to think about when you hire outside counsel, and for outside counsel to think about as well when issues come up, because it looks like the courts are pretty clear on this particular one. Hypothetical, Company A is a parent. This one's a little more complicated than I wanted to be. Company A is a parent. Company B is a subsidiary of A. Company C is a subsidiary of B. And I put this one in here because reading through these cases, this was kind of one of the examples of just how complicated these things are. I mean, these cases have a lot of really weird facts, but you can see where it can really come up to bite somebody. Lawyer worked for Company A, so was hired by Company A. Their paychecks come from Company A, the parent. It says parent right on their paycheck, but all the work was really for the sub C. Company X comes in and purchases C from B, so Company C is no longer gone, or no longer there. And as part of the bargain, the lawyer from the parent went from A to X. Okay, so she now works for the buyer. Company X sues Company B for breach of contract, and Company B moves to disqualify the lawyer. I thought this was really complicated, and this just gives you an example of personnel, the talent. The men and women at these companies are going to move back and forth sometimes, so issues can arise. And the answer in this one is the court ultimately determined no. Company A could not expect lawyer not to use all he had learned while with Company A and working on Company C matters. So he was with A, but the facts of this particular case, the lawyer said no, they can come on, they can work in the other direction. So obviously these are cases that have been fully resolved. Again, our encouragement is to disclose these issues up front, get agreements, and try to work these things out before they're an issue. Most of the time, if you can wall folks off, you prevent all this litigation, the heartache that goes along with it. Another hypothetical, lawyer for seller in a stock sale represents all the selling shareholders. The majority shareholders call the lawyer and want to confidentially talk to them about their specific issues, which are quite different from the minority shareholders, which is often the case, because the majority shareholders run the business day to day, and the minority shareholders, of course, are just inactive. The majority shareholders were receiving consulting and employment agreements and not just price per share like minority shareholders. We got a conflict here. Can the lawyer answer those questions if the majority shareholders are specifically asking the lawyer, what do I do to make sure my piece of the pie is bigger than minority shareholders? How does the lawyer handle that? Does he have a conflict? The answer is, of course, this is a conflict, and this is a direct conflict without disclosure. A lawyer may have a conflict of interest if their ability to consider, recommend, or carry out an appropriate course of action for the client will be materially limited as a result of the lawyer's other responsibilities or interests. In that situation, you must disclose to the minority shareholders what you're doing. Perhaps another lawyer would have to be appointed for them, but these are real issues you want to think about, because the last thing you want is to open up your client to potential litigation from minority shareholders, because that's where I get involved. Shareholder litigation is real. It happens quite often, and you want to try to nip these things in the bud early. So think about them. You want to help when they pick up the phone, and often in situations like this, the majority shareholder is who you're communicating with. That's your direct point of contact. And she may be the one calling you because she's the majority shareholder and she has everything, and your bills may be getting paid. But if you're representing all the shareholders, you must keep that in mind, because that is a direct conflict if your advice is different. Hypothetical, you're a general counsel for Target Corporation in a stock sale. Buyer requires, as a condition of closing, the Target Corporation, owned by the selling shareholders, enter into employment agreements with senior management, and many are selling shareholders. Who do you represent, selling shareholders or the Target Corporation? The answer, you could represent both. And this is another example of one that I literally put in there just because I'm reading through these cases, and the facts are so wild on some of these. I mean, you know, these are cases that you come up with, you're like, man, it'd be hard to come up with an idea or a possibility of how this would ever recreate itself. So the point is they're out there and they're real. The facts will change. The law will change based on the facts. This is another one you would just want to be very careful, be upfront, and try to get things resolved. So again, as I mentioned, how do you handle the conflict when it arises? I just think there is absolutely no substitute. You must disclose. You must disclose to your clients. And if you work at a firm, obviously, talk to the person in charge of your ethical issues at the firm. Try to get these things worked out. If you're in-house, consider discussing the same thing with folks who may be handling those issues. Consider talking to other counsel as well to make sure things are going well, because ultimately as in-house counsel it's going to fall back on you if there's a problem and the company's sued. So you want to make sure that that is taken care of. And only proceed if you have consent, and obviously in writing explain the risk and advantages. There are a few cases out there where the entity that is being charged with the conflict and have messed everything up basically said, no, we orally talked about it. Not good enough. Once you get this resolved, make sure you get it in writing. It doesn't even have to necessarily be a formal agreement. There's some examples of those, but you want to make sure that somewhere in writing you have something where that has been agreed upon. And whether it's an email and they email back on a smaller matter, even something, make sure you've got it in writing. And again, informed consent under the ABA comment says, aware of the relevant circumstances and of the material and reasonably foreseeable ways that the conflict could have adverse effects on the interest of that client. So again, saying you must be very specific. That's all I have. Do you have anything else to add, Mike? Or
I do not. Does anybody have any questions for us? I'm still reading, Mark. So this is an interesting question that I've never thought about. So I'm going to call it Mark Wickham. So
we're about to hear Abbott on the law.
Good question. Yep. The question is, if seller is being merged into buyer but does not want buyer to own any pre-closing privilege, then who practically would buyer transfer the privilege to? One of buyer's executives who will not be employed by seller post-closing. The instances where I've seen this come up and where it can happen is actually it goes to the merged company's shareholders. So think of it kind of like a merger, also kind of like an equity transaction where you have shareholders, which works when they're being, well, either cashed out or if they're, I think, taking equity even of the buying entity. There is some precedent, obviously, in Iowa where that has been done. So I think the answer would be I don't think it would be to the employees, the officers of the company, but I think a privilege could be transferred to its equity owners would be where it would go.
Do we have any questions in-house?
All right. Thanks everybody for your time.
Thank you.